One. This is The Legend. 105.3, 95.3, WDXE.
And here we are with the Stan Pierchoski himself, Stan Pierchoski and Bulletproof Estate Planning, as our Fridays go.
It is myself, right?
Yeah, it is you. You live and in person.
It's the version of me that made it over here through the
you made
monsoon.
Is it still raining?
Well, it wasn't too bad. It was
Still
kind of
raining
off and
out
on, but just before I left, it was raining pretty hard, and then it kind of quit.
Yeah.
But it's a lot of debris on the road, a lot of high water.
Yes.
Nothing that kept me from getting here, but some spots where you got to slow. There's some stuff that washes down out of the hills, and you got these like pretty big branches in the middle of the road. That,
oh yeah.
It's like bad as hitting an armadillo.
Yeah, we've had some reports here and there of roads with some condition issues and things that. So you need to be careful out there.
So it's going to rain for a lot of the day, so it's going to start draining eventually. But yeah, lots of water.
Lots of water. Storms, and we've heard some news in other areas of the country that storm system has caused some damage. There were some tornadoes and some people suffered damage, even some casualties we heard. I hate to hear that.
Well, it is that time of year. It's usually more like April, but
we're fortunate here in that we've got such good weather eyeballs. We've got the weather people here that really look after us and give us plenty of warning if you're tuned into it. So you can always do that.
It's always impressive to walk through the weather station. I think they're moving some of that somewhere else, right?
It's already moved.
Yeah, but I mean, when we used to walk through here, it was pretty impressive.
Yeah, it's impressive, and it's even more impressive now. They've got bigger studios and a lot more capability, that kind of thing.
Cool.
I was over there not too long ago. Very good.
Yep, glad they're looking out for us.
Well, now see, did you have a seminar since I saw you last?
No, it's tomorrow.
It's tomorrow.
We have a big seminar tomorrow, but it's over in Pulaski. I want to talk about that for just a minute because I want people to understand that my seminar schedule is changing a little bit. There's several reasons why. Some of it is that we go to several counties,
yes,
and we go to places by invitation. So we go to many counties by invitation. We do some private ones or quasi-private where I get invited by a church or an employer, or a business to talk to the employees, and sometimes even banks. We give our seminar to. So we do a lot of them, and as a result, we sort of like are throttling back on the ones that we do now. So I'm doing one in tomorrow in Pulaski at the Star Theater, right on the square, the big community theater there. Yeah. And it's the building that's right next to my office. And it's probably going to be the next one I do in Pulaski. It might only be one more throughout the whole rest of the year.
Yes.
And so I don't know, I haven't seen the schedule yet. I know the girls are putting it together. And I don't know when. There'll probably be another one here in Lawrence County, but probably only one more for the whole rest of the year. Now, whenever I have them, I'm not too far away. So, like if you hadn't been to one and you want to, they used to come around relatively often.
Right.
That's going to change. But if you need to come to one, I mean, it's no big deal to drive to Pulaski if you're here in Lawrenceburg or vice versa to attend these things. But they're not going to be. They're going as we cycle through the different counties and where we go, it's going to be several months before we come back to the same spot.
Okay.
So we're having one tomorrow. If you hadn't been to one and you want to, it's a pretty easy 20-minute drive to Pulaski, and rain should be out of here. It's supposed to be a nice day tomorrow. So
yes,
we do that at 10 o'clock at the theater over there. We call it Will's Trust in the Nursing Home, and it lasts about an hour to an hour and 15 minutes, and it's a presentation that I think you'll definitely learn from because everybody that attends it does. And it's I think the information you learn will be new to you. I think it'll be inspirational to you because a lot of folks who feel there's not much that can be done will find out that there really is a lot that can be done.
Sure.
So
sure.
Come hear what we have to say. I mean, it can't hurt. Invest an hour. If you decide to do something, I offer really good price incentives on what we do for people who spend an hour or so with me to get pre-educated.
Absolutely.
If you're going to spend an hour and 15 minutes, and a lot of folks are there for another half hour to 45 minutes with the question and answer period. So if you're going to spend that time with me on a Saturday morning, we'd like to pass that on to folks and just give them some incentives for.
Good thing to do, I can tell you.
Get over this procrastination hump.
Good thing to do, I can tell you.
And so that's. Like I said, I don't know when the next one's going to be here in Lawrenceburg. Maybe I should know maybe next Friday or two.
Yeah.
And I'll announce it.
Good deal.
So, give us a call at my office. It's a Pierchoski Estate Law, Pierchoski Elder Law at 931-363-7222. And get on that RSVP list. The RSVP list is very informal, but we do like to get a head count.
Yeah.
So, the last one we had here, we pretty much maxed the place out. So that head count was very helpful.
Yeah, helpful.
And we had something like I don't know, 15 or 18 just walk-ins, which are welcome, but
Yes.
we want to have a seat for you and a table and stuff like that. So,
Very good.
yeah. So,
Very good.
anyway,
Well, you and I were talking off the air and listening to the news just before we came on the air, and we got to talking about judges and judges' decisions and things like that. The decision regarding the prosecutor down in, what is it,
right.
Georgia?
Georgia.
So, and I didn't understand the decision. You of course, are an attorney.
Well, I didn't. I'm sure I heard it because we sat down, they started, and I kind of went and I sort of tuned in halfway through. It sounded like they said one thing and then contradicted
Then
it.
said something else. Well,
but, yeah.
that's okay. But I made the comment that sometimes these judges make decisions, and I wonder how in the world they made the decision they made. And of course, I am not an attorney or a judge, but that I had heard something, and I asked you about it. And this has not a lot to do with estate planning, but you may know the answer anyway. If you're a Supreme Court justice of the United States, do you have to be an attorney to be one? And I heard that you did not.
Okay.
Do you know anything about that?
Well,
Because if that would be a really good job for me.
I think so too. I think so too. I like that one too. The answer to that is no. Okay, it's like anything else. When you want to know, like, if there's requirements, right?
Yeah.
They're somewhere in the rules, right?
Exactly.
Now, for the Supreme Court of the United States, the highest court in the land, the rules are actually in the Constitution itself, and there's nothing more than an age requirement and a residency requirement. And that also goes for Congress and the House of Representatives and the Senate. None of it says you have to be an attorney. I mean, that would be kind of limiting, I think. Now, it typically is because most of those positions, not all of them, a lot of them non-attorneys could fill.
Sure.
But something like all the judgeships in the Supreme Court, I mean, I don't see how you could do an effective job if you didn't have an understanding of the law and the way things work.
Yeah.
Because, and I'm going to kind of dovetail this into estate planning in a way,
Okay.
or any area of the law, but how it kind of works for us. But
Sure.
so you don't have to be. Okay, the requirements are minimal.
Yeah.
And all the stuff going on, there's not even a disqualifier if you have a criminal record or something.
How about that?
But the Constitution defines the Supreme Court, and it says that then the Congress can define the lower courts. But the only court that talks about it in the Constitution is the Supreme Court. Article 3, the executive powers reside in the Supreme Court. Right. Article 1 is with the legislature, Article 2 is the presidency, and Article 3 is the judiciary.
Yes.
And it just says, what they'll do and basically what they'll do. And then they set up the lower courts, and that's Congress that sets up the lower courts. And they kind of set them up accordingly, but nowhere do they ever have the requirement that you have to be an attorney. I think you have to be learned in that, you have to be qualified for the position. Now, that can encompass a lot of stuff. Okay. And not too long ago, when I started practicing law, it was in 2002, we had several places, and there may still be, but I knew then of several counties where our General Sessions Court, that's our low court,
yes,
where the General Sessions judge was a non-attorney.
Yeah.
And that's still allowed. But, I mean, I think the ones I knew have since retired and moved on. But, there was not uncommon to find that. So, again, I think you may be at a disadvantage. Now, those lower courts and the Chancellor divisions and the General Sessions Court. But when you get into the Circuit Court and higher in the appellate courts, I mean, everything is governed by rules.
Yes.
And you have to know and understand the rules. Now, here's why it's very important that the people like our Supreme Court and the appellate courts are very qualified people. When they make a decision, that is the law.
Yes.
Okay, it's called our common law. It's not codified. It's not in a statute anywhere. They will interpret. So let's say something comes down and you don't like the decision. You think it's wrong. Okay.
Yes.
Which
happens a lot.
It does happen a lot. And the courts will analyze it when it's what they call, sometimes it's a question of first impression. If the courts have not ruled on it before, they'll hear it and rule on it. When they rule on it, that is the law on that particular subject matter. And that's what everybody's bound to. Now, usually what happens after that happens, if it's not codified and this court makes a rule, the legislature will, within a year or two or so after that, make a statute out of that ruling.
Yeah.
But, the effect of not making a good decision at the Supreme Court level is a problem. And it has happened over time, over our history, a time or two, that a decision came out of there that was not the greatest, and it ended up getting overturned by a subsequent Supreme Court
Sure.
for good reason. So I mean, but for the most part, it's what they come out with is basically right. You know, they analyze the question up one side and down the other, and
Yes.
they found their decision in law and authority, and they back it up, and they
Yeah.
you know. Now, how is that useful to us in estate planning? Though it can be, and you have heard me on this show or maybe on my other show, occasionally discuss court cases that come out on that subject of
Yeah.
estate planning.
Right.
And the reason that's important is because if the courts rule in favor of something, then that's, I look at it like, well, that's kind of what we want to do. I want to do what the court said is okay to do.
Yeah.
And then sometimes you'll see the court will strike something down and say, we're not going to support that. And I learned that those are things I don't want to do.
Right.
Because I know
You
the
can
court's
avoid
not,
the pitfall.
Yeah, I know court's not, if that gets to court, they're not going to support it. And the lower courts are bound by what the higher courts say. So if you get into, if the decision's been made that, like in our 10-care planning, if a decision's been made at the higher courts that, that this is considered a countable asset, when you get to the lower courts, they're going to look to see what the higher court said about this, and they're going to find those cases, and they're going to say, well, I'm bound. This is mandatory authority to me because I'm a inferior court to this one, and so I have to follow what they call stare decisis, which is once settled, always settled, and once they settle it, that's the rule, and we have to live by. So
Yeah.
I have often talked about cases that have come through trust writing or wills that they've invalidated, or wills that they determined whether it was valid or not, and it has to do with estate planning. And there were some pretty neat ones. I don't know if you remember the one I talked about not too long ago, where when we talk about our trusts, I tell people when you leave property to your heirs in trust, you can put any terms or conditions on it you want.
Yes.
Absent any illegal purpose, of course. But if you want to say, you get, if we could say something completely off the wall,
Yeah.
like say you get $500 the third Thursday of every fourth month at 10 o'clock in the morning, we'll issue you $500 of your inheritance for the next 50 or until it's all gone.
Right.
Something. I'm just spitballing. Okay.
Yeah.
That's what will be enforced because that's the way the trust law works. That's the instrument that they'll uphold. And I talked about a case like that because a lot of people, when they come to my seminars, that surprises them that you could put in there whatever you want. Like I said, it has to be something that's not illegal.
Yes.
But it's like I said, it surprises people. So when this court case came down, it was a Tennessee case too, and that's why it was so important. In a nutshell, it was kind of like a mom left her. She had a daughter and a son, and she left them 50% of her estate. And it specifically said that for the daughter, I'm just going to leave it to her outright. She just gets it. No terms, no conditions, no strings attached. But for my son, she said, if he's still married, if he's married to the woman he's married to at the time of this writing, because they didn't name names, but if he is married to the wife that he has now at the time I'm writing this trust, then I want his 50% put into trust, and his sister, the trustee over it, and she's to make sure that he metered out, and there were some reasons what things he could use it for and things he couldn't use it for. But she said if he's not married to that person, then he gets an outright distribution just like she does. He just gets it. So if you read between the lines, Mom was not too crazy about the son's wife.
Sounds like it.
She was not too crazy about her in-law. Now, I don't know if it was she didn't like her or didn't trust her or just figured she'd blow through his money. But for whatever reason, she felt a need to protect it.
Yeah.
If she was in the mixture, she saw a problem there. Again, it was silent on what her concerns were, but that was definitely a concern of hers.
Yeah.
Now, that's kind of specific, right?
That is very
well, and the son thought so too.
Yeah, I bet he did.
And he was still married to the woman at the time of her death, and he was ticked off. Okay, he was not happy about that. So he decided to raise an issue and say, well, I think that's a violation of my right to own property. That should come to me and just come to me, And so he took it to the courts.
Yeah.
And I really had to hand it to the courts because as I started reading, I thought, here's how I think. I say to myself, here's how I think this is going to turn out.
Yeah.
And here's what I think is really the right answer. And the courts did exactly that. And what they did is they analyzed this thing according to the rules. And so they go to the trust code, and the trust code says, okay, the legislature has said when you write a trust, the trustor's intent. Now, the trustor is the author of the trust, the people who write it. The trustor's intent is paramount. And the legislature said the intent will not be disturbed absent compelling evidence to do so.
Yes.
Okay. So nowhere in law do I see language like that.
Yeah.
And that's strong, strong language. They're saying, hey, whatever you put in this trust, which I call the rule book, right?
Yes.
Whatever you put in there, we're going to uphold unless there's some compelling reason. That's a strong term, compelling reason to disturb it. And so I don't know what that even could be. But so if you put in there, okay, every fourth Thursday of every third month at 10 o'clock, we're going to bring you a glass of orange juice and we're going to give you $500 in your inheritance. I mean, that's what the trustor wanted. That was their intent. And now that intent is paramount.
Yeah.
And if there's any reason, if you can, some compelling reason why you're not going to bring them orange juice and $500 at 10 o'clock in the morning on that day, they're going to leave it be. So I'm being silly, okay?
Yeah.
But I'm driving a point home. And that's what the courts looked at this and they said, you know, this when you on these revocable living trusts, you are a beneficiary at the whim or the stroke of a pen of the trustor. Okay?
Yes.
And they said she chose to give it to him, but she wanted to conditionalize it. And under our trust law, the trust is the instrument that controls. The only time we use the trust code is if you're silent on something and we got to go fill the gap.
Interesting.
And they pretty much said, you know, she was very clear. And she said, since he was still married, he could only get his inheritance one of two ways: directly, outright, or he gets it in trust controlled by his sister. The thing that depended on is who he was married to at the time.
Right.
He chose to be married to her at the death, and so we're gonna enforce that this is the way it goes to him. And they struck his and it went to our Supreme Court. And they said,
wow.
So can you put in there whatever you want? The answer is yes. And if you do, that is what will be enforced.
Yes.
Now most people just kind of leave it outright, but a lot of people have reasons to protect it. You know, we've talked about it from time to time. Suppose you got a kid who just blows through money like water.
Yeah.
Now, some people take, and I'm not advocating one philosophy over the other, but here's the philosophies I see my clients have. Some say, you know what, I'm going to leave it to my kids. If they blow it, that's on them.
Yeah.
And okay, I get that. That is maybe teaching them some financial responsibility.
Yeah.
And that's a school of thought that I think could have some, you know, I can see the effect of that.
Sure.
But some others have the position, you know, okay, my son's a spendthrift. He's going to blow through this. And I don't want my inheritance just to be a big party for him. I want it to be a good start on something.
Yes.
A good start, like a few examples would be like, you know, when he gets settled down, maybe help him with a down payment on a house.
Right.
Or if he's an entrepreneur, he wants to open up his own business, and usually that's hard to do because you haven't got the wherewithal to do it. He can maybe use that to start his own business.
Exactly.
Or maybe somebody that wants a further education.
Right.
And they can't go to get the education because it's so expensive. You know, the stumbling block there is the tuition.
Yes.
I want a good start for them. I want it to be something that will enhance their life, right? And if they know they're a spendthrift and they're just going to say, hey, I get this jacked up truck and have a party and just blow it on that, they don't want that to have be done. He said, oh, you know, if he wants to spend his money on his truck and have a party, that's great. But I don't want him spending my inheritance for that.
Yeah.
And so that's a school of thought. And if that's the case, then we need to protect it. So we need to control how they get it, just like in that court case. We're going to say, okay, we're going to either meter it out to you and say you get, 5% a year for the next 20 years. And I guess the theory there is at least you can't blow it all at once. And maybe over the next 20 years, you become financially responsible.
Right.
Or you can give it to another person and be the steward of that money and meter it out for what you put in the trust to be good reasons.
Yes.
Okay? Or you can incentivize it. Say, hey, here's $100,000. It's all yours, but you can only use it on a college education. I don't know if that sounds like a bit much. $50,000.
Yeah.
I mean, that's an incentive. That's another school of thought.
Sure.
Is you can say, I'd really like you to get an education, and I've removed the stumbling block of tuition, but that has to be used on that. Now,
Right.
I wouldn't just say college. I would say post-secondary education, stuff like that. I wouldn't rule out some of the other trades and stuff like that. But I mean, so those are all reasons. Those are all things and reasons that you can put on your inheritance to get what you want. Now, let's think about it. People might say, well, you're straddling that child. You're making it hard for them.
Yeah.
Let's back up a step. If it's me, this is my stuff I'm leaving.
Yeah.
My concern is what I want for my children, not what my children want for themselves. Do you see the difference?
Yes, there is a
If
difference.
my son thinks the best thing for him is to blow it on a truck and a party, and I disagree with that, if he feels put out because I leave it in trust with his sister and only meter to him,
Yeah.
I mean, tough horse hockey as far as I'm concerned. I mean, I'm looking out for his best interest. And I
Right.
guarantee you that if as time goes on, long after I'm gone, there's going to be a time when he would thank me for doing that.
Probably so.
And so, I mean, but if, it's up to you, you, the person writing the trust, if you want to control it and keep them from squandering it or using it or giving it away, then control it.
Yeah.
That's up to you. It's your stuff. You're leaving it to them. This is a windfall to your heirs. There's no other way to put it. It's pure gravy, right?
Yep. You're using the term inheritance.
Yep.
Inheritance. And I was thinking about this in fact, yesterday I was thinking about the fact that you would be here this morning. I thought, there's something I want to ask him about. And it has to do with inheritance because
Please do.
you're controlling, with the trust, you're controlling how the inheritance is distributed according to your wishes. But you hear the term inheritance tax a lot, especially bounced around with the politicians and all that kind of stuff.
True.
Can you talk about and clarify what an inheritance tax is and how it will or will not affect you?
I can. Now, not being a tax attorney and that being a very cumbersome area of the law.
It is.
But I can give you the general topics and
Okay.
the general understanding. Now, a state can impose an inheritance tax.
Yeah.
The state controls.
Is there a difference in an inheritance tax and an estate tax?
Well, that's what I was going
Go
to get.
ahead. Okay.
And the answer is yes, but here in Tennessee, no.
Oh, here we go.
Property descent and distribution. When I say descent and distribution, I'm talking about after death, how it passes down and out to the individuals. Okay,
Right.
like by will, by intestate succession, by trust.
Yes.
Whatever the instrument controlling the property, it's governed by state law. Okay, so when you write a will, we look at the Tennessee Code to see what makes it valid.
Right.
And I've gone over those statutes in
Right.
here to show. So Tennessee can have an inheritance tax, and they used to have one. Now, it got repealed some time ago. So, let's go to a state that does have one. An inheritance tax is a tax. I mean, here's a good way to, if there's a special tax on winning the lottery, then there is.
There is.
That's what an inheritance tax is. It's tax sheerly on the fact that you get this money by descent and distribution of somebody passing away.
Yes.
It's a tax on that. It's a specific tax. It's not sales tax. It's not income tax. It's not excise and franchise tax. It is not. It is an inheritance tax. It's on the tax on the fact that you inherit property.
Okay.
Now, some states still have it, so I don't spend too much time looking into it. But I deal with Tennessee. Tennessee repealed theirs some time ago. I don't remember the year, but it was a while back.
Okay.
And we don't have that. Okay. So. What still does exist is an estate tax. Now that is not governed by Tennessee law. Tennessee doesn't have an estate tax. The federal government has one.
Okay.
And the federal government has capped that estate. That estate tax is right now it's like $13.6 million per person. And if you're a married couple, you can tack those two together, and get up into 27.2 million. Now, every dollar over that is taxed at a rate of like 40% on estate tax.
So an estate tax is not going to affect you unless it is
A certain amount in your estate.
in your estate, and that amount is pretty big by most people's
Well,
standards.
and by 2025 or 26, they're talking about pulling it back, and it's all over the board, but like to 7 or 8 million or something. It's part of what President Trump did, and it has an expiration date in 26, I think.
Okay.
But they're thinking of keeping it high, but maybe not that high. And every year it goes up. Like last year it was 12.9.
Okay.
And January 1st it jumped to 13.6, which is purely cost of living or inflation increase. And so it does that every year anyway. And that's quite a jump, right? I think that jumped $500,000.
Yeah. Well, for most people, then an estate tax is really not going to affect
Exactly.
them.
I mean, here in small town Tennessee, I don't see estates like that.
Interesting.
They're very, very rare. I don't even know if I have dealt with a taxable estate.
Yeah.
I dealt with some that were getting close, but not. But so there's that tax. Now, there's other taxes that can intervene in estate planning. Now, here's one that is some people find a surprise, and that is if you leave property to a child, and if that property you leave them to, let's say you have this property and you pass away, and the only thing you have to leave to your child is you have your house, your real estate, and some money in the bank. Let's just keep it those two things. Now, when you leave them the money in the bank, and it's money in the bank, it's not CDs, it's not stock, it's not an Edward Jones account. It's $100,000 in the bank. Right?
Just straight up money.
That's
in
right,
the bank.
cash.
Okay.
There's no inheritance tax on that. There's no tax on the fact that the person is inheriting that by virtue of somebody passing away. It's not an estate tax. But that is going to be an income event. Because the heir suddenly has $100,000 of income in that particular calendar year, and that is going to cause an income taxation event.
Okay.
Okay. So you're going to have a tax effect, but it's not inheritance, it's not estate, it's income.
Aha.
It's a whole, it's unearned income, and so there's going to be some consequence of that. Now, there's ways to defer and mitigate that kind of stuff, but it is a bunch of income you're getting. Now,
True.
Did you have a question? Because I was going to jump to the real estate next, but go ahead.
No, I just clarifying.
I can see.
So it's hitting income tax, not estate tax,
Right.
but it affects your income.
It is income,
and you still have to pay income taxes.
That's right. I was going to say, we're on radio and people can't see. Well, I guess we can see us, but when I'm sitting here looking at Jeff, I can see the wheels turning.
There's a question mark.
I can see the wheels turning when a question's brewing. Now, let's switch over and talk about the real estate.
Yes.
And let's just say, you say, I leave my real estate to my son.
Yeah.
Now, that's not income, okay? But it could be a tax on that, but it would come in the form of a capital gain, okay?
Uh-huh.
Now, capital gains at death, go away. Capital gains are kind of cumbersome to understand, but let me see what I can give the Reader's Digest version.
Here we go. Okay.
Yeah. So let me use you for an example. You and your wife have a home, and when you have a home and you bought it, you probably bought it some time ago, and you have in that home what's called a tax basis, which is kind of what you paid for it. So let's just say you bought your house and you paid a flat, even $100,000. I'm using numbers that are easy to use on the radio.
Okay, I'm with you.
$100,000 is your tax basis, and let's say now over years, easy numbers, now it's worth $200. Okay, let's just say if you sold it, you can get $200 for it. So let's just say you decide to sell it and get $200 for it.
Yes.
So I'm using easy numbers. If you sell it for $200,000, you have a $100,000 capital gain.
That's right.
That is the gain above and over your basis. Okay. Now, if you realize that gain, meaning you just put the money in the bank and keep it, and after 180 days, it's still money.
Yes.
That's called realizing the gain. Now you owe a capital gain tax on that $100,000.
Right.
That can get pretty high. It can get as high as 40%, but it's typically about 28.8%. But it's a pretty good chunk of money. Okay.
Yes, it is.
Now, if you roll it into, you can avoid all that by buying another piece of property of equal or more value, which is what most people do.
Yeah.
And now you're not paying the tax; you're literally kicking the can down the road.
That's correct.
The tax is going to get paid someday, but not this time. And you can do that; those 1031 exchanges and stuff like that. Now, so if you sell that, you incur that gain, right?
Yes.
Now, there's two ways to give property to your children. One is to give it to them during life, an inter vivos thing.
Yeah.
Or the other is to give it to them after death, either in a will or a trust, right? Let's talk about life. If you give them the property during life, an inter vivos transfer, they are going to get your tax basis. So you got a $100,000 piece. You have this piece of property. Your basis is $100,000 from 20 years ago.
Right.
You say, son, I'm giving you this property. Here it is. Here's the deed for $10, love and affection. Here it is. He gets your tax basis. And the reason is there's no bargain for sale or exchange. So there's no creation of a new basis.
Right.
So the law is he has your tax basis. Now, if your son turned around and sold it the very next day, you have just handed him a $100,000 capital gain liability, did you not? Because he's going to sell it for $200 and his basis is $100.
Right.
So that's one of the disadvantages of giving stuff away at life. Because if you have somebody that bought a farm,
Yeah.
in the 50s for $50,000.
Yeah.
Now it's worth $1.5 million, right?
Yes.
And you give it to your kid, and now the tax basis, the basis is, the gain is gigantic, right? The capital gain is huge. So,
Yes.
So, sometimes we have to do that, but it's not always the best thing to do. Now, let's say you say, you know what? You talk to your wife and say, let's leave the house to our son at death. Let's put it in our trust. Son, here's the house for you.
Yes.
Now, here's something remarkable happens, and that is when he inherits the property, he now gets, because you're leaving it to him at death, he gets what's called a step up in his basis. Now, the basis is the tax basis, right?
Yes.
Yours is $100,000. When he gets it, his tax basis on the real estate is now going to be the fair market value the day of death.
Okay.
Which, in this example, your house is now worth $200,000, right?
Yes.
So his basis is $200,000.
Okay.
Now, if he turned around and sold it the very next day, no gain, because it's the fair market value the day of death, right? Now, if he keeps it for 20 years and it goes to $300,000 in value, he'll have a capital gain, but it's going to be his own capital gain, but it started from the stepped up number. So
Yes.
that step up in basis is a huge benefit to your heirs to leave real estate that way. Now, it's not just real estate. If you leave them stock, let's just say you invested in Home Depot stock or whatever,
Right.
cannabis stock, I don't know. But if it's worth more when you give it to them than it was when you bought it, and there's some folks that buy stock in one of the local banks many years ago, right?
Yeah,
And it's
yeah.
got some value to it now.
Yeah, absolutely.
So, there's a capital gain there if you cash it out and sell it. But if you give it to the kids, they get a step up in basis on that. So if they ever do sell it, their gain doesn't start or it starts from that stepped up number. That's a tremendous advantage to the heirs.
Yes.
So that's why it's usually not a good idea to give away property during life unless there's some other compelling reason to do it.
Oh.
In which case the capital gain. And now, sometimes that'll happen to people. They give it away. I had this exact circumstance. They gave the farm. And why do people give it away during life? The most common reason is they feel like they're going to avoid long-term care issues by doing
Yes.
that. Okay,
Yes.
they think if it's not my name, they can't take it.
Right.
And so they give it away. And now if the child sells it, he's got this huge capital gain. This is a real example. A farm that had a basis of about, I want to say $50,000.
Yes.
And now it was worth over $1.5 million.
Yes.
And they gave it away. Now the child has his capital gain. Now, the child's planning on keeping it because the whole reason we gave the farm to the child is because it's a working farm, stays
Yes.
in the family for generations, and they want
Right.
to keep it there, right?
Right.
So the person they gave it to is going to just continue keeping it and leave it to his kids. And I said, here, if you do, just leave it to them at your death, like in a trust.
Yes.
And they will get a step up in basis to whatever it is, and that'll cure the problem we have right now.
Yes.
If you don't sell it, capital gains is not a problem. You can have as much gain as it wants. It's not an issue until you sell it
Correct.
and realize the gain. Then you have to
Interesting.
pay the tax. But if so, we got this. You got we sold it for $50,000. We got a $1.5 million capital gain if we sell it.
Yeah.
Just leave it to your child in a trust at death. He'll inherit it. His basis will now jump to the fair market value the day of your death. So anything your parent did when they gave it to you has all been cured.
Yeah.
And it would just cut to the chase, and everything's been fixed. But if they do sell it, then you're not straddling them with a capital gain.
Okay.
So we got there from taxes, I guess somehow.
We
but,
did. Yeah, we were just talking about inheritance.
But those are the taxes that affect inheritance. They're not inheritance taxes. They're not a tax because you inherit money.
Right.
They are taxes that can rear their head just because you come into ownership of property or cash, stuff like that. It's
Right.
not necessarily. The stuff about the money. There's no different than if you found a bag of money on the street and had $100,000 in it, and you did what you're supposed to do and reported
Right.
on your tax return. You suddenly came into $100,000 more income that year. That's going to have an income effect.
Does this same and how would this affect if there is valuable personal property that must be sold?
And you say sold for what reason?
If in an estate situation.
Oh.
Okay. Let's say there's a pretty good value of personal property and it's liquidated.
Only things that you can actually establish a basis for.
Okay.
And that would go for things like if you had in your personal property you had collected some gold coins or something.
Yes.
Or if you collected some diamonds or something that you can actually establish a basis for.
Okay.
I mean, all the stuff you're talking about is personal property.
Yes.
But stuff like heirlooms, the collectibles, I mean, it's hard to put a basis on those things.
Yes.
As a matter of fact, it's literally impossible. So it's not typically an issue, but here's the dividing line. The language is a little bit nebulous, but the dividing line is that only applies to anything that personal property that rises to what we call investment grade. Investment grade is like this: you take a bunch of your personal property and you sell it and you buy gold coins with it.
Yeah.
Okay. Now, when you purchase those coins, you've established a basis.
Yeah.
This happened to me one time.
Okay.
I mean, that's maybe why I understand it so well. It was a real life experience.
Yeah.
It was some years ago, but I don't know, I can't remember why, but I bought some gold coins. I don't know, about 8 or 10 of them.
Yeah.
And I bought them.
Yeah.
And I had them for, I don't know, I can't remember how long I had them. But at some point in time, I sold them because I bought them for a reason and I sold them for the reason I bought them. But
Yeah.
there was some time in between. I sold them. And, it's all in my bank account. You can see where I bought it and where I sold it and stuff like that.
Right.
So I filed a tax return. And I got a letter a couple of months after I filed a tax return that said, you owe some taxes. And they explained that it was based on this sale because when they sold the coins, I don't know, let's say it was $10,000.
Yeah.
There's nothing in this record that shows what you paid for them.
Interesting.
And so they said what they're saying was, I mean, he said it in so many terms, but you distill it down to what they said. They said, you have this sale of gold coins and you got $10,000. Nowhere is there any documentation that shows a basis what you paid for it.
Yeah.
Because the income is the amount over if you sell it at a profit. That's what income is, a profit, right?
Right.
So if I'd have paid $5,000 for them and showed that I paid $5,000 for them and sold them for 10, what they're saying is we're going to tax you on the $5,000 of income that you made.
Correct.
But they said since there's nothing in here to show a basis, we have to assume the whole 10,000 is income. And I thought, oh, great. So I started looking through some old mail.
Yes.
And I remember there was mail from whatever, and you find a bunch that are not opened, right? Because you get these things and you say, yeah, I'll look at that someday. And I started looking through them. And sure enough, fortunately for me, I found the documentation where I bought them,
Good.
which is what I needed, okay? And it turned out that it actually turned out even better, well, better tax-wise, but not better buying gold-wise. It turned out when I sold it at a several $100 loss.
Uh-oh.
So, like, if I paid $10,000 for it, I sold it for like $9,500 or something like that. It was something less.
So you took a hit.
So I sent it in, and then a month later, I got a letter saying there was zero liability on my tax return because now they saw that I didn't have any gain, I didn't have any income on it,
Right.
so there was no tax. But without that basis, so that's a good example of this basis versus the gain that you can get, and it works for all property.
Yeah.
So if you're talking about personal property, if it's something like that they can establish a basis, they will apply it.
Yeah.
So if you decide I want to invest in I want to shelter some money, so I'm going to buy some diamond necklaces and stuff that I think hold money, hold value. Well, there's a basis in that, and it's like it's like investment grade stuff.
Right.
So usually personal property we don't give too much concern about, and even if you had something collectible, part of the statute says valuable collectibles.
Yes.
I guess if you had Paul McCartney's original guitar, that was worth a lot. Okay, they could do something like that.
I can name one better than that. Willie Nelson's guitar.
There you go.
That's probably the most famous guitar in the
I think
world.
it just sold not too long ago, didn't it?
Oh, really?
Didn't somebody?
No, he's still playing.
There was a guitar that's. Yeah, you're right. There was a guitar that sold. I can't think of whose it was, but it was like a couple of million. It
Seems like I remember something about that.
I mean, that happens a lot, but
I would imagine that his guitar is going to wind up in a museum of some sort somewhere. But anyway, that's a long story.
There's a lot of things like that.
Yeah.
I mean, there was the ruby slippers that Gardner wore when she was in Wizard of Oz, and they auctioned off some time ago, and it was a lot of money.
Yeah.
So stuff like that.
I've been telling about meeting a lady up in Hendersonville in recent days, and we're looking to plan a sale for her on a lot of collectibles that she has. One of the things that she has was it was hanging on the wall. It was a needlepoint, an old needlepoint. And it was done by Betty Davis.
Oh, good grief!
How about that?
Yeah.
So she was at Betty Davis' estate sale or some sort, and bought that.
Yeah.
And I thought that was pretty cool.
Yeah, I mean, it's amazing. Don't let the pickers know about that. They'll come up there and they'll take all that good stuff.
That's right. That's right. That's some very interesting stuff. I'll have to show you some pictures.
And some of that stuff, you think about it, what is that worth? I mean, you think
what's
that's probably
worth?
That's probably worth a lot. Well, it might be worth a lot to a Betty Davis fan.
Yeah, it's so much fun.
And if there's somebody that I don't even know who Betty Davis is and don't care, it's not worth much to them.
That's right.
So the basis is such a subjective thing. That's what makes it hard to do the tax thing. Who's going to establish the basis?
Right.
Stuff like real estate, coins, gold, stuff that you actually can buy and see the purchase value.
Right.
Yes, that's stuff we can see. But personal property, I mean, if you leave your dining room table to your kids, they're not going to say, okay, down here at Story and Lee, you paid $1,200 for this table, and you give it to them. Now we think it's only worth $200. Yeah. So I mean, it's too cumbersome. Yeah. I've never known anything like that ever happen. It never will. So
I agree. I mean, and we see that a lot. We see that a lot with some of the estate sales, and you have things that really wouldn't be worth anything at all to anybody but the family members. Maybe.
I always tell people, I call it your stuff, right?
Yeah.
You got your stuff, and you got some stuff that at the end of the day you can't even give away.
Yeah,
right?
that's true.
I mean, my house is polluted with it.
Yeah.
I keep stuff for a reason, but nobody else would want it other than me. Other than me.
I got a pile of stuff like
You
that
know,
myself.
I'm not a hoarder, but I mean, I have stuff.
Yeah.
You know.
Everybody has stuff.
And when you it's a good example of something we can talk about. And that is, people ask when they're doing a trust plan, how do they deal with that? I said,
Yeah.
well, here's what we do.
Yeah.
You have these specific distributions you can have, and if you have stuff that you want to go to somebody,
Yeah.
like let's just say, my wife says, I want my wedding dress to go to my granddaughter, my firstborn granddaughter. I want her to get my wedding dress, and I have a child that's a motorhead, and we have this old beat up diesel that he's been helping me restore,
Yeah.
and we work on it together, and it's fun doing it. It's fun doing it together. It's kind of a bonding time,
Right.
So I'd say, I want to leave that diesel to him because it was a bonding thing for
Yeah.
us, and it would be nice. Or you just want to leave a lump sum. So I got 8 grandchildren. I just want to leave them all $5,000 each. And
Yes.
so you're going to give these specific distributions of property.
Yes.
Then you have whatever's left, the residual. And that's all your stuff. I mean, your pots, your pans, your tables, your chairs. I mean, this stuff. And now, how do we dispose of that? Well, let's say I got 3 kids and I'll get a third of everything. Well, my successor trustee, I give them discretion to do a couple of things.
Yeah.
One is we sit around the table and say, okay, what do you want? You say, okay, I want this big old conference table with dads. That's cool. Okay, what do you want? Well, I want that old motorcycle in the garage or whatever.
Right.
Or I want this. And at the end of the day, the successor trustee's discretion is everybody, you put a little value on everything, and everybody's bucket at the end of the day is kind of equally full, as best
Yes.
you can do, right?
Right.
And if everybody agrees that, yeah, I'm happy with this as being
Right.
value, it's the same value as that. Now you got the stuff that nobody wants. My kids don't want.
Yeah.
So you can have a yard sale. If you have a yard sale and sell it, money is easy to divide, right?
Yeah.
Now there's stuff you can't even sell, right?
Yeah.
I mean, there's no such thing as a yard sale, and at the end of the day, all the tables are empty, right?
Yeah. We got to get rid of this stuff.
Doesn't happen. So you got stuff you can't even sell. So you have discretion to go give it to Goodwill,
Yes.
or literally go take it to the dump. I mean, it must be dealt with. It has to go somewhere.
Right.
So we build in discretion for them to deal with all that kind of stuff that has. I mean, if you say they have to sell everything and divide the money, I mean, what if they can't?
Well, I want to tell you we're being listened to.
Oh, great.
I got a text from a buddy. The 15 most expensive guitars sold at auction, and the first one was over $6 million.
Okay.
Can you believe that? Kurt Cobain's Martin D18.
Wow. Oh, cool.
Anyway, and I don't know if this person wants to talk to us.
Well,
or not.
we hadn't given the number out, but
We
you might
have
as well
it.
answer.
We'll see. Hey, good morning. You're on WDXE with us.
Yeah, I want to talk about the trust just a little bit.
Okay.
There's this case of this grandson. His grandfather died, and everybody else had already died off. The only one that was left was the grandson. So the grandson was going through his grandfather's papers, and he found out that the grandfather had left the house in his name, but he had to be 30 before he could sell it. And he's only 25 right now. And he's found out that the lawyer that wrote up the papers and the bank that the father dealt with, the grandfather dealt with, everybody's died and gone, and the bank's gone out of business or changed names or something. So the lawyer's no longer living, and the bank doesn't exist. But the grandson found that he has to be 30 before he can sell the grandfather's house. Is that true?
I'm gonna tell you what. Can we hang up and you listen on the air?
Okay.
All right. Okay. Thank you. Yeah.
All right. I guess by saying is that true, is that valid?
Yeah. Is that valid?
Well, first of all, the only thing I don't know, and maybe I should ask whether they're still in the line, but what they found that said, what they said, it has to wait till he's 30 to sell it.
Yes.
I'll assume she said it was a trust question, so I'll assume that was written in his trust, or
Yes.
perhaps written in his will. Or something.
Yes.
If it is, then the answer is yes, that is enforceable. Now, it has nothing to do with the lawyer that wrote it being passed away.
Right.
It has nothing to do with, I'm not sure where the bank would come into play, but
Right.
But if the banks are out of business,
Right.
that is his intent, and that is enforceable if he memorialized it into an enforceable agreement. And the
Yes.
enforceable agreements that we have are a trust or a will. Now, if I just don't know, but if the child found a yellow sticky note granddad wrote down, I don't want him to sell the house till he's 30, not enforceable.
Right.
Okay, and that makes sense, right? Now, and this is exactly what I'm talking about. Remember we said earlier in the show that you can put in these documents whatever you want. Now,
Yes.
he probably said you can't sell it to your 30, but then didn't give any reason why that was the thought process. So we don't know. You can kind of guess at it and think, well, maybe he wanted him to have the house, and if he gave him a place to live, but if he wanted to go out and get his own house or something, and he could do that, but he could at least have this house for a certain term of years while he's on his feet and not straddled with a new house or something. Or maybe he thought, I just don't think a person's financially responsible to get several $100,000 when they sell a house until they're at least 30 years old.
Yes.
So, like I said, assuming that the requirement that he doesn't sell it until he's 30 isn't an enforceable instrument, that is 100% valid. And that is a cloud on the title, and that will surface. So if he goes to sell it, and of course, you get a title insurance company that gets involved in that, they'll find that. They will find that, and they will find out. Then they'll say that is a defect on the title for him to sell it. In other words, he left it in his name, but he can't. You know what I mean? So he's going to have to. It's going to be a problem.
I've run into other circumstances that are similar but different, in that when something is put in the title of a property, and it's left in effect, or we run into it on properties that have restrictions. Mm-hmm. Or that can't be sold for this purpose.
Right.
Those kind of things are enforceable.
Yep.
I mean, they stick.
And I want to bring that up in contrast to something.
Yes.
I said if it's in this instrument, it says he doesn't get it till he's 30 years old. What happens is the deed will never be transferred to him until he's of that age.
Okay.
Okay. So ownership hasn't passed yet.
Yeah.
Now, if you give it to him at death at 25 years old and you deed it to him, like if you deed it to him in a will or something like that, and put that condition on it, it's less enforceable because now you've given the child ownership of the house. And I think that's what the lady said she said he gave it to him, put it in his name, but said he can't sell it till he's 30. Okay?
Yeah.
Now, that would require some more language somewhere to hold that to him.
Yeah.
To hold him down, because here's the thing: you can't deed property to somebody, give them ownership, just pass ownership 100%, and now dictate terms of what they can do or do with it or not do with it.
Yes.
But you can dictate those terms as a condition of the property being deeded to you.
Yes.
You could say, hey, I want you to go to college. When the day you graduate from college, my trust is going to deed the house to you.
Yeah.
On your 30th birthday, we're going to deed you the home. Now, once we deed it to you, the ownership of a piece of property, as you know, resides in the deed. Yeah. That's all there is. Game over. There's no other way. It resides in the deed, the name on the deed. So if you deed property to somebody, and then say, people even put language like that in the deed. Say, I'm deeding it to my son Joe.
Right.
But he can't sell it till he's 30 years old.
Right.
Now, that's going to be unenforceable because it's what we call a restriction on alienation.
Yes.
Alienation is the right to buy and sell property.
Yes.
And if you say you can't sell it till you're 30 years old, or you can't ever sell it ever, like some folks say, that's a restraint on that alienation.
Yes.
And if you say you can never sell it ever, that's a violation of our rule against perpetuities.
Yeah.
So the way to do that, so I guess what I'm saying in this case, absent more information, it could be enforceable, but there's reasons why it may not be. It needs to be looked at. But so the way we come across that, we say, okay, I'm going to leave this property to you in trust.
Yes.
Either my trust continuing, or I'll make a new trust and leave it to you. And the terms and the conditions of the trust are, you get the property, but you can't sell it till you're 30 years old.
Yeah.
That is enforceable, and it doesn't violate perpetuity because there's an end. We know know when it's going to end. And because you're not alienating, not a restriction on alienation, because the fact that you get the property in trust, the trust can control the terms and conditions of the property.
Yeah.
And so you could do it that way. And that could be done with a will and what we call a testamentary trust. So I don't know what happened when the grandfather died, but I need a little more. But it sounds to me like it probably is enforceable from the way she described it. But we didn't have enough time to ask a bunch of questions about it. But
it's like anything else. Anything can be challenged, but whether or not you win is another thing.
Well, that's true. I mean, and that's why if that's what you want to do, right? Let's use that as an example.
Yeah.
If that grandfather was still alive, or if we rewind back to when he was, and that was really important to him.
Yeah.
Hopefully the attorney that is no longer living anymore drafted that and did it in a way that it would be, in fact, enforceable. I mean, you can challenge it. It's not a question of whether you win or not. It's a question of whether what you're going after was valid or not. If it's valid, you're not going to win. If it isn't valid, you will.
Yeah. Yeah.
And so there's a right way to do stuff like that, especially with real estate. If you want to condition, the easiest thing to do is say, you just don't get the deed in your name. Yeah. The deed's going to stay in my trust, and they can stay open after death for a very long time if you want. After my death, my trustee, my successor trustee, will deed it to you on your 30th birthday.
Yeah.
That is 100% enforceable.
Yeah.
If you give him the deed now, at the end of it, whatever, probate, or the trust just said give him the deed, or something, now it might be a little more questionable as whether or not he has the right to sell it at 30 if he already owns the property.
Right.
Because if you own it, you own it.
That's interesting.
I hate to be oversimplistic, but you either own it or you don't. And if you own it, you can do whatever you want with it, right? If you don't own it, you can't do what you want with it. Right. So it really kind of boils down to those fundamentals.
It does.
We probably couldn't. I'd be more than happy to answer more questions about that if there's a concern with that.
Let's do that. She may want your number, and we've got a couple minutes left.
Yeah,
we need to establish how to contact you for folks that may not know.
That's right. First of all, the seminar, day after tomorrow. No, tomorrow.
Tomorrow. It's tomorrow.
Tomorrow, Saturday, over at the Star Theater in downtown Pulaski, right on the square, right next to my office. It's actually 105 North First Street, but you find a square, you'll find the theater.
Absolutely.
And we're doing that at 10 o'clock in the morning. We call it Will's Trust in the Nursing Home. We won't get into issues like that, but if you do have any questions about anything we talk about, or a question about the seminar, call my office at Pierchoski Estate Law, Pierchoski Elder Law. The number there is 931-363-7222. Or you can go to my website, which is easy to get to. It's actually Pierchoski Estate Law, but if you don't want to spell that, you can put estateplanstand.com. And
that is an easy way to do it.
It'll get you right there.
estateplanstand.com.
So, if you want to come to the seminar and call, just let us know that you're thinking about coming, how many you think are going to come with you. Yeah. If you can't commit to come till the morning of, just show up. It's okay. Usually got plenty of room. They're actually doing a show over at the theater that starts 1st of April. It's Joseph and the Amazing Technicolor Dreamcoat.
That'll be great.
That starts April 4th, and it's a couple of weekends, and tickets are on sale for that now, as a matter of fact. But we'll be in the audiences where I set up for my seminars for that.
Great.
So, but if you have any questions, if you want to come to a seminar and you have a question, like this young lady that called, if you have a question, bring it with you, and then when we get the Q&A, bring it up. If you develop any during the seminar, which a lot of people do, jot it down. Yep. We have this Q&A at the end, and it's very comprehensive. I always say, I'll be the last one out. I'll stay until the last question's answered. So no problem. So again, let me give the number again: 931-363-7222. I do that because somebody once told me, hey, you only give your number once and you say it too fast. So 931-363-7222 or estateplanstand.com. So,
That's great. That's great.
Hopefully we'll see you tomorrow at the seminar.
We've had an interesting discussion today, man. It's been really good.
Yeah, and if not, we'll be back here next Friday morning at 8 o'clock for Bulletproof Estate Planning.
That's right. That's right. Always a pleasure. Estate Plan Stand, everybody. Bulletproof Estate Planning every Friday here from 8 to 9. 8 to 9. And good Lord willing, we'll see you next Friday.
Always a pleasure, Jeff.
Man.
A ruling in the Trump case out of Georgia. I'm Dave Anthony. The DA that the former president wanted removed from the